Welcome to COVID Conversations with a Lawyer. My name is Thomas, and with me is my partner Cyrus. Today we are privileged to have Ms. Anandarajah from Rajah and Tann, LLP, who will be speaking to us about competition law. Ms. Kala heads the Competition Antitrust and Trade Practice at Rajah and Tann, and has handled multiple major cartel and abuse investigations, as well as numerous multi-jurisdictional merger notifications around the world. She was a recipient of the Public Service Medal in 2014 and has received numerous accolades for her work in not just competition law, but in trade, employment, corporate governance, and environmental law as well. Good morning, Ms. Kala, and thank you for having us here today. Maybe we could begin with some. Hi. Maybe you could begin with some general questions about competition law, so that our viewers can get a sense of what the law entails.
Absolutely.
Yeah. So maybe let's start with what is competition law?
Okay. So what is competition law? Competition law is intended to ensure that there's fair competition in the market between businesses. It is to ensure that there is sufficient choice for individuals going into the market to buy something. So if I put it very simply, for instance, if you wanted to buy a new product, whatever it may be, you go into shop A, you get it for $500. You go into shop B, you get it for $500 as well. There's no competition. The price is the same. And that's, in a sense, what competition law wants to try and prohibit. If that price had been fixed by the two shops talking to each other or colluding with each other, that is called anti-competitive. That is an anti-competitive behavior which will violate the law, violate competition law. One other quick statement on what is competition law. Competition law essentially, in very sort of summary terms, intends to regulate market behavior. So the description I just gave you. Competition law also tries and regulates the structure of the market. What I mean by structure is mergers. If you have three big players in the market and say two of them decide to merge, you're going from 3 to 2. What kind of impact can that have in the market? That's also, in a sense, part of competition law.
I see. So would you say that competition law actually or doesn't actually obstruct competition?
I would go with the view that competition law does not obstruct competition. Of course, to the average individual and to me as well, sometimes it's counterintuitive. We look at it and we say, you're trying to prohibit me from putting the best price out by talking to my friends as well. That way we all win. Mm-hmm. But who's the real loser? It's the end consumer. It's the smaller shops buying from the bigger guys who come together to cartelize or to abuse their dominant position as such. So competition law is intended to try and make the environment fair. And maybe just to add a very quick point here, the regulator for competition law is the Competition and Consumer Protection Commission of Singapore. It's the CCCS for short. In the name of the commission, you see competition law, and that's what they try and protect. But you also see consumer protection. So the CCCS also manages consumer protection issues. In terms of consumer protection, obviously we're trying to prevent unfair practices and consumers being abused, for example. The very common ones are, you go and buy a holiday package or you go and buy a spa package, for instance, and then you're taken for a run. A few days ago, there was an article in the newspaper about a guy who had gone to a neighborhood shop for facial, and he got charged over $4,000. That's consumer protection. Mm-hmm. If the shops have agreed that this is how they're going to charge, the competition layer comes on top of that as well.
Okay. So let's say in the business context, would competition law allow me to coordinate and discuss my business and plans with my friends who are in the same business, or would it prohibit me from doing so?
Okay, so the short answer is don't talk. Do not talk. do not go out to dinners, have drinks, and whatever not, where you're going to talk shop. Okay, so this is again very counterintuitive, because when you go out for lunch, when you go out for dinner, you're there to sort of share ideas. You're there to say, oh, you know, business is really doing badly, or business is doing so well, or we get this sort of pricing from this particular company, and so on and so forth. But when you discuss those issues, that's when potentially you're violating competition law. You're sharing price-sensitive information. You're sharing commercially sensitive information, which allows you and your friends to sort of collude, to coordinate your behavior. And competition law wants to try and prohibit that.
I see, I see. So would I, let's say, be able to discuss with my supplier, for instance, so that I get a better deal than my competitors?
Okay, that's a very good question.
Yeah.
Sorry to cut you off. So that's a very good question. So when I talk about you and your friends being competitors, I'm looking at it horizontally. When I talk about you and your supplier, who could also be your friend, I'm looking at it vertically. I hope you can see the hand movements. When it's a vertical transaction, competition law is a little kinder. If you're going in to negotiate a better deal, one-on-one, you with your supplier to get a better deal, the answer is yes. You can coordinate, no issues. Well, I shouldn't say you can coordinate. You're not coordinating, but you're negotiating for a better deal for yourself. Let me flip that a little bit. If you and your horizontal competitor friends come together and say, we're going to go and negotiate together with this one supplier, then you might have a problem at the horizontal level. You might have a problem. Okay, and that actually leads us very nicely into some of the problems that many businesses face at this point in time.
Okay. I mean, now with COVID and all this, businessmen are sort of coming up with innovative ideas to improvise and be more competitive in a sense. So if, let's say, my competitors and I were to sign a 5-year joint marketing agreement, would that be allowed?
Okay, so question is, what is your joint marketing agreement for? Historically, without COVID, we would need to scrutinize that a little bit further, because like I said, it's a horizontal agreement, right? Why can't you individually go to market? But with COVID, a lot of these businesses have faced disruption. So it's been very difficult in a sense for them to try and attract more customers into their shops. Or if they're going into the digital world, you're trying to attract traffic into your digital sort of online shops. Sometimes joint marketing makes that easier, right? Because of the COVID situation, the CCCS has issued the set of guidelines known as the, let me get you the exact name, known as the Guidance Note on Collaborations between Competitors in Response to COVID-19 Pandemic. It's a mouthful, so we'll just call it the Guidance Note. The Guidance Note was issued primarily in a sense to sort of give businesses a bit more guidance on when they can come together to collaborate. So entering into a 5-year marketing agreement, is that going to be acceptable? We would need to look at a few issues. Is this something you could have done on your own? Not possible? Fine, come together, do it. But what is your marketing agreement collaboration looking at? Is it about general marketing issues? Or are you sharing very specific details about your products, your cost structure, your manufacturing process? If you're going into all of those details, probably they will say cannot. Okay, and that's the traditional way you look at it. Now, how does the guidance note sort of relax that a little bit? It says that we'll allow you and will be a bit more flexible, but will allow you only until July 2021, assuming that you've been fair about the structure as such. If your 5-year, so you asked me about 5-year agreement. The 5-year agreement will obviously cut this July 21 period, the time period. And so the immediate answer is going to be probably not. let us examine it a little bit more under normal competition laws. And that's when some of the questions that I asked come into the picture as well.
So just now you mentioned about horizontal agreements between, let's say, my company and my competitors, right? So let's say if currently in the COVID climate, due to the scarcity of certain raw materials for the manufacture of some of our products, so can I agree with my competitors that each of us will limit the quantities of raw materials that we order so that we can continue with our manufacturing business? Yeah.
Okay, so this applies to many businesses out there because you all want to ensure that you survive the COVID period, right? Without the COVID, without the guidance note, the short answer is no, you can't. The moment you come together and you say, I will only buy 15 tons, you buy 10 tons, he buys 20 tons, and you agree the quantity, that's anti-competitive. That's going to be a violation of the law. But because of the current COVID situation, the way we look at it is to see how we all sort of emerge out of this. If this is the best way of ensuring the businesses survive, of ensuring that the consumers out there continue to have enough choices, or I shouldn't just say consumers because it depends on where in the value chain we are. So as a manufacturer, you're going down to your distributor or your retailer to ensure that value chain survives as well. The answer is yes, it might be possible. It's really, at the end of the day, establishing the net economic benefits. Now, I know that's another technical term that I'm introducing. It's a very common phrase used in competition law. We are always doing a balancing act. So we're looking at the net economic benefits coming out of the collaboration. And in a COVID scenario, we're going to say that this is typically anti-competitive, but doing this will save the manufacturers. It will also save the downstream value chain, potentially. That's essentially how you kind of work it and say, can do.
I see. So let's say to ensure that no customers are left unserved, let's say in this period. So would it be possible for, let's say, my company to collaborate with my competitors and designate which of us can supply which customers in this case? Yeah.
Okay.
What do you think about this?
So again, a classic question where I would say normally if you want to do this, right, and if you're a client coming to me, yeah, don't do it. It's not safe. Because again, you're talking to each other. Again, you're saying, I, Kala, supply to customer A. You, Cyrus, supply to customer B. We're deciding who's doing it. That is wrong. The customer should be able to come to us and decide who they want to buy from, right? And that will also mean that they potentially can get the best price because the customers will pit you and I against each other to get the best price. When we collaborate, it means that is taken away. Even in a COVID situation, I would say that this one, unlike the earlier example, it's a little bit trickier. I don't think we should be doing it this way unless there's a very, very good reason. Maybe it's the distance of supplying, the cost of transportation or logistics, for instance, which makes it more sensible for you to supply and not for me to supply. We can find some justification. Otherwise, this one, I think, riskier. And again, if I use a technical term, it is classic market sharing. Okay, so I would say be careful.
I see, I understand. So moving on from, let's say, between my company and customers, let's say if we take a look at delivery services, which is quite common now during the COVID situation. So can I pool my delivery services with those of my competitors, given the way that, let's say, we are organized? All the clients related data will have to be shared among us, but would this be allowed under the law? Yeah. Okay.
So under the law without COVID, I would say it is possible if you structure it properly. Within COVID period, probably a little bit more flexible in the sense that, again, it's shortage of potential drivers, right? Because of COVID and stay home and staggered timing and so on. And then the quantity to be delivered is also potentially reduced. It doesn't make sense for each of the businesses to have multiple drivers, multiple trucks on the road. So to try and minimize cost, you pool. If you can justify that that's the reason why you're pooling, and like you say, you put in the proper sort of structures to prohibit or to prevent the sharing of too much confidential information, I think this will work. When I say sharing of too much confidential information, obviously schedules of when you deliver will be shared, but can't be helped. Obviously, the quantities of what you deliver and perhaps the kind of product will end up being sharing because the delivery guy can see it. But again, that I think can't be helped. But you don't go on and share how much more volume you're going to be sharing, delivering in the future. What is your price range and so on. Don't share those. And if you work it that way, I think it's acceptable. And for this one, right, the UK, so the UK Competition Authority is known as the Competition Markets Authority. What they did this year was go a little further than the guidance note that the CCCS issued. So they went a little further, they issued a note, guidance, but they also expressly identified certain exemptions. For instance, they said that various suppliers could pool and share their staff for delivery purposes. They could even, if necessary, and this was for the supermarkets. So supermarket retailers can, so they've gone a little further, can go ahead and share data on their stock levels, their distribution depots, their delivery vans. They can share all of this. In normal times, they can't do that. In Singapore, can they do all of this? I think our guidelines don't go so far, but if we can justify and find that net economic benefit as such, the balance, I think we may be able to push the boundaries a little bit. And this is something businesses probably will want to be able to do.
I see. Thank you. So moving back to my previous question, let's say if we talked about, just now you mentioned about the price increase of raw materials in this current situation. So in this case, is it possible for me to coordinate with my competitors to pull together our orders to benefit from volume discounts, for example, like buying in bulk, so for lower price, etc.?
Okay, so again, there's a pre-COVID and there's a current COVID scenario. Pre-COVID, if you're going to pool your resources together to buy, right? What we say is this critical resources to your business? If it's very critical in terms of running your business, as opposed to say buying pen and paper, which may not be so critical to your business, then we say no, you shouldn't be pooling resources. You need to go and negotiate individually, buy individually. Again, for the reasons I cited earlier, we want to be able to have that competition come about because parties negotiate with each other. However, now, because it's the COVID scenario, I think for certain types of products, in terms of if it's relating to essential services, so if you're talking about medicines, you're talking about masks, you're talking about toilet paper, you're talking about food supply and so on. I think in these areas, as simple examples, if you want to sort of pool your resources and coordinate to buy, to get the volume discount, it's going to be okay. The second, if you're buying the non-essentials like pen and paper for your business, and I consider that non-essentials in the sense that I'm assuming you're not a printing company, then it's okay. But if you're buying sort of the non-essential type products and not something that's critical to your business, then you've got to exercise a bit more caution. Why is it that you need to pool? And the NEB argument, the net economic benefit argument, will need to be effectively shown. Again, as I say this, right, I know there's some technical elements to this. And unfortunately with competition law, the rules are very simple. Don't talk to your competitor. So when you pool, you're actually talking to your competitor. And that in itself creates problems. It creates issues in terms of how much sensitive information have you shared and what impact is that going to have downstream to your distributor, to your retailer, and to the end consumer going into shops to buy things. Yet, competition law is not absolute. It still tries to see how best to help businesses. And in bad times, it says, okay, we allow a certain amount of collaboration. I hope that's giving you a sense of the answer. It's not clear-cut 100%, but it tells you you can, because COVID's there now. But as you collaborate, as you think about what you're buying, maybe talk it through a little bit more. When I say talk it through a little bit more, go to the website of the CCCS, look at their guidelines, understand it, talk to your colleagues within the organization, and then think about whether you can go ahead and do it. Not go straight away, talk to competitors.
I see.
Okay.
Thank you. Yes. All right. So moving on from what you mentioned previously, in particular about the essential goods and services, and this is something that's mentioned by the Ministry of Trade and Industry. So I was wondering, let's say my competitors and I would like to share production lines and inputs to increase output and reduce costs during this period. So, but we do not produce the stuff that are listed within the essential goods and services mentioned. So would that be allowed?
Okay, the risk here is going to be a lot higher because whilst I keep saying that because we want to try and allow you to survive, the Competition Commission has introduced the guidance notes. They allow collaboration on a wide range of things, but it's not collaboration on anything and everything. So if you're going to be sharing production lines, why? How do you justify the need to share? Is it because a question of saving, you can say saving costs, but what costs are you really, in a sense, trying to save? And then how do you structure the timing of the production? The technicalities associated with this, again, is important because you're not producing the essential goods. If you're producing essential goods, no issues. I would say you can go ahead and do this. But because you're non-essential, you don't fall within the Ministry of Trade and Industry list, right? It then suggests that the normal competition rules will apply to you. And unless I can show really good reasons, and just reducing costs alone is not going to be enough. Just survival alone is not going to be enough of a reason. It's going to be a tough call for this one. I'm not saying cannot. I'm saying it's a tough call.
I see. All right.
Okay, maybe now we could move on to vertical agreements that sort of constrain the market. So, I mean, now due to COVID, there's a lot of scarcity for certain raw materials and for the manufacture for certain products. So could I, let's say, agree with my supplier that he will not supply my competitors unless imports return to normal? This sort of restrictive behavior, would it be allowed by the law?
No, cannot. Okay, even as I say no, cannot, right? One key thing we need to look at is take a step back. Is my supplier a very big guy? Meaning he's a player who has a strong market foothold. We call it dominance, okay? Or market power. If he has a strong market foothold, and then you tell your supplier not to supply to your competitors, outright prohibited. It is an abuse of dominance by the supplier, even though it may have been instigated by you, the purchaser, the buyer. However, if there are many suppliers in the market, then it's like if I go to my supplier and say you don't supply the rest, maybe not so much of a competition issue in Singapore.
Okay.
The answers are different in Malaysia and Indonesia and other countries. But in Singapore, we'll say, okay, we allow you. Why? Because in Singapore, when there are many players in the market, so there's no market power or dominance as such, we go with the position that, the current state of the law allows for an exemption where there's no market power. So I can enter into these kind of agreements. I can tell my supplier this. So critical element, if you are in this kind of a scenario, look at what your market power is. Are you small? Are you large? And then make the determination.
I see, okay. Okay, but let's say now, considering the increase in delivery services and online orders and all this, would I be able to appoint a home delivery service provider on an exclusive basis and sort of restrict him from doing deliveries for my competitors, let's say?
Okay, so again here, it's the point that I made about, do I have strong market power? If I have strong market power, myself, I have strong market power, and then I look at the delivery guys. Are there many, many, many delivery guys in the market? If there are many delivery guys in the market, and I appoint one exclusively, one might say, hey, not a problem. But those other delivery guys, do they have enough shops to deliver for? Or is the market sort of dominated by me, that if I do an exclusive with one delivery guy, the others are going to suffer? Now you see all these side issues kind of come into competition law. And if I say that those guys are going to kind of suffer, we end up with a potential violation of competition law. So again, it's not because I want to give like iffy maybe answers. It's a lot of facts that we need to look at. Having said that, right, I think in the Singapore context, just ballpark, looking at whether it's the supermarkets or whether it's food and so on. I think for now, for short terms, if you want to have that exclusivities, it might work. Even as I say that, I got to correct myself. I think with food delivery, we need to be a little bit more cautious, because if you look at the number of players in the market, it's not a large number. I won't name them, but it's not a large number. But if you're looking at the supermarket, you're looking at just raw materials, you're looking at other consumer type goods being delivered, I don't see a problem. I think it can be done.
Okay.
So now, let's say moving away from the vertical agreements issue. So I was wondering, moving back to, let's say, essential services, competition. So currently, do you think it will be possible for me, let's say as a company, to collaborate with mask manufacturers, and as part of my offer in my shop, I offer free masks with any items bought from my online shop? Do you think this will be allowed?
Okay, so I'm assuming you're not the mask manufacturer, and you supply other goods, you sell other kinds of goods. So what we are looking at here is not the horizontal competitor to competitor. Neither are we strictly looking at the vertical in a sense. We're looking at another word, conglomerate. It's a cross. So what I'm trying to do is, or what you're trying to do is, in your shop, you sell all these products and then you bundle or you tie the mask to that product and you sell. Can you do that? I would say yes, no problem. There are many reasons I can say to try and argue that, if you have dominance, there might be issues and all that. I think that might be going too far for this session. Straight off, I would say no problem. I don't see a competition law issue in the description that you just provided.
I see. So moving on with this, let's say, promotion kind of issues or collaborations. So let's say for a business in a shopping mall, if they want to attract more customers to their outlets to boost their business, and they can they offer a special package to customers? So I can give you an example for this. So let's say all restaurants in the mall will offer a $10 discount to customers who have purchased a product in any of the mall's outlets. Would this fall foul of any of the laws under competition law?
So this is a very real example, very good question to sort of touch on. Why is the mall doing this? The mall is trying to increase footfall, obviously, right? And again, it's not the strict horizontal, it's not the strict vertical. It's a kind of mixed conglomerate. The mall, by getting people to go to all the other retail shops and spend some money, and then saying, okay, then you get a $10 rebate in the restaurants, or the restaurants offer the $10 discount, and then you go and buy a product in the other outlets as such, is considered a benefit. It's considered a benefit that aids the end consumer going into the mall. It increases the, he gets a discount, but by him going into the mall and others likewise, it increases the footfall. So hopefully the food outlets get more business, but also the other retail outlets get more business. And that way, the mall owner who's collecting rent from everyone also benefits because he is able to collect his rent. So you see the benefits at the many different levels. And that's what competition law wants to try and encourage. And they will not put a stop to this kind of activity. So again, perfectly acceptable. In fact, a good practice, which is seemingly bundling things, tying things, and yet well within business activities, something to do as such. So a very good thing to do.
I see. Thank you for the clarification. So actually we don't really have much questions else that we'll be asking you. So I was just wondering, perhaps as a general summary, would there be any parting words that you want to leave with regards to the impact of COVID on competition law? To sum it all up.
Thanks.
Yeah.
Sure. I'm just going to put this out there. For smaller businesses, you might think that you're very small and you can't influence market behavior. The answer is you can. In your small little ecosystem, you can. And if you look at all the cases that the Singapore Competition Commission has looked at, you will see that many small businesses have been pulled up for, be it coordinating who wins a tender in electricity, or who wins a tender in the supply of specific products, or what price do I sell potentially my products at. There have been many, many different cases that have come up. Not all of them are the multinationals. Not all of them are huge, big ones. Many of them are the SMEs. And SMEs range. You've got the big SMEs and you've got the small SMEs. It is important for all SMEs to understand that when you talk to your competitor, he may be your best friend. You may have both gone into business together and now you do separate shops, but you still share information. That is a problem. So my bottom line is, when it's competitors, don't talk about business. Don't talk about what your plans are. Don't talk about anything which is commercially sensitive. And I always joke that, if you're into soccer, talk about soccer, or I should say football. If you're into badminton, talk about badminton. If you're into food, talk about food. Anything but your direct business. And then on the flip side, if you're a really big guy and you know you have market power, just remember, cliche as this might be, with great power comes great responsibility. So if you are big, you must go to market in a fair manner. You cannot have exclusivities. You cannot push your terms and conditions on your value chain down the line as well. I hope this has been helpful. A lot of technical things, but at least something to think about, and hopefully for you to look further as well. Thank you.
All right, thank you so much, Ms. Carla. With that, we've come to the end of this session. Thank you so much for listening in, and we hope to hear from you soon.
Thank you very much again.